Good day, everyone. We are the Group 3, and our topic for today is all about
The idea of public reason. According to John Rawls, the idea of public reason has to do with how questions should be decided, but it doesn't tell you what are the good reasons or correct decisions.
Political society and every reasonable and rational agent, whether it be an individual or a family or an association or even a confederation of political societies, has a way of formulating its plans, of putting its end in an order of priority and making its decisions accordingly. The way a political society does this, its reason, its ability to do these things is also its reason, though in a different sense, it is an intellectual and moral power rooted in the capacities of its human members. In autocratic regimes, when the good of society is considered, this is done not by the public if it exists at all, but by the rulers whoever they may be. Characteristics of a democratic people. It is the reason of its citizens, of those sharing the status of equal citizenship. The subject of the reason is the good of the public. What the political conception of justice requires of society, basic structure of institutions, and of the purposes and ends these are to serve. Reason then is public in three ways: as the reason of citizens as such, it is the reason of the public. Its subject is the good of the public and matters of fundamental justice. Its nature and content is public, being given by the ideals and principles expressed by society's conception of political justice and conducted upon to view on that basis. The idea of public reason has been often discussed and has a long history, and in some form it is widely accepted. Here is to try to express 1 to 10 an acceptable way as part of a political conception of justice that is, broadly speaking, liberal. In a democratic society, public reason is the reason of equal citizens who, as collective body, exercise final political and coercive power over one another in acting laws and in amending their constitution. The first point is that the limits imposed by public reason is the reason do not apply to all political questions, but only to those involving that we may call constitutional essentials and questions of basic justice. This means that political values alone are to settle such fundamental questions as who has the right to vote, or what religions are to be tolerated, or who is to be assured fair equality of opportunity or to hold property. Most political questions do not concern those fundamental matters. For example, much tax legislation and many laws regulating property, statutes protecting the environment and controlling pollution, establishing national parks and preserving wilderness areas and animal and plant species, and laying aside funds for museum and the arts. Number 2. Another feature of public reason is that its limits do not apply to our personal deliberations or reflections about political questions, or to the reasoning about them by members of associations such as churches and universities, all of which is a vital part of the background culture. Plainly, religious, philosophical, and moral considerations of many kinds may here properly play a role. Public reason and the idea of democratic citizenship. They ask, why should citizens, in discussing and voting on the most fundamental political questions, honor the limits of public reason? How can it be either reasonable or rational when basic matters are at stake for citizens to appeal only to a public conception of justice and not to the whole truth as they see it? A legitimacy principle is connected with two special features of the political relationship among democratic citizens. First, it is a relationship of persons within the basic structure of the society into which they are born and in which they normally lead a complete life. Second, in a democracy, political power, which is always conceived power, is the power of the public that is of free and equal citizens as collective body. Third, why The apparent paradox of public reason is no paradox is clearer once we remember that there are familiar cases where we grant that we should not appeal to the whole truth as we see it, even when it might be readily available. Consider how in a criminal case the rules of evidence limit the testimony that can be introduced, all this to ensure the accused the basic right of a fair trial. On fundamental political questions, the idea of public reason rejects common views of voting as a private and even personal matter. One view is that people may properly vote their preferences and interests, social and economic, not to mention their dislikes and hatreds. Democracy is said to be majority rule and a majority can do as it wishes. Another view, offhand quite different, is that people may vote what they see as right and true as their comprehensive convictions direct without taking into account public reason. Number 1. The nature of public reason will be clearer if we consider the differences between it and non-public reasons. First of all, there are many non-public reasons and but one public reason. Among the non-public reasons are those of associations of all kinds, churches and universities, scientific societies and professional groups. As we have said, to act reasonably and responsibly, corporate bodies, as well as individuals, need a way of reasoning is public with respect to their members, but non-public with respect to political society and to citizens generally. Non-public reasons comprise the many reasons of civil society and belong to what I have called the background culture. In contrast with the public political culture, these reasons are social and certainly not private. To illustrate the rules of weighing evidence in a court of law, the rules relating to hearsay evidence in a criminal trial and requiring that the defendant be shown guilty beyond a reasonable doubt are suited to the special rule of courts and needed to protect the right of the accused to a fair trial. Different rules of evidence are used by a scientific society and different authorities are recognized as relevant or binding by different corporate bodies. Consider the different authorities cited in a church council discussing a point of theological doctrine, in a university faculty debating educational policy, and in a meeting of scientific reasoning association trying to assess the harm to the public from a nuclear accident. The criteria and methods of these non-public reasons depend in part on how the nature, the aim and point of each association is understood and the conditions under which it pursues its ends. In society, non-public power, as seen, for example, the authority of churches over their members, is freely accepted. In the case of ecclesiastical power, since apostasy and heresy are not legal offenses, those who are no longer able to recognize a church authority may cease being members without running afoul of state power. Whatever comprehensive religious, philosophical, or moral views we hold are also freely accepted, politically speaking. For giving liberty of conscience and freedom of thought, we impose any such doctrine on ourselves. The government's authority cannot then be freely accepted in the sense that the bands of society and culture, of history and social place of origin, begin so early to shape our life and normally so strong that the right of immigration, suitably qualified, does not suffice to make accepting this authority free, politically speaking, in the way that liberty of conscience suffices to make accepting ecclesiastical authority free, politically speaking. Nevertheless, we may over the course of life come freely to accept, as the outcome of reflective thought and reason, judgment, the ideals, principles, and standards that specify our basic rights and liberties, and effectively guide and moderate the political power to which we are subject. This is the outer limit of our freedom. We may also distinguish between a single role or a group of roles, an institution or a major part thereof, and the basic structure of the social system as a whole. The concept of public reason. This content is formulated by what I have called a political conception of justice. Three things broadly liberal in character. 1. It specifies certain basic rights, liberties, and opportunities, kind familiar from constitutional democratic regimes. 2. Assigns a special priority to these rights, especially with respect to claims of the general good and of perfectionist values. 3. Affirms measures assuring all citizens adequate, all-purpose means to make effective use. Conception of justice is political. 1. It is framed to apply solely to the basic structures of society, political, social, and economic institutions, a unified scheme of social cooperation, presented independently of any wider comprehensive religious or philosophical doctrine, elaborated in terms of fundamental political ideas. Number 2. Essential that a liberal political conception include its principles of justice. Conception has two parts. A. Substantive principles of justice for basic structure. B. Guidelines of inquiry, principles of reasoning and rules of evidence in the light of which citizens are to decide whether substantive principles properly apply and identify laws and policies that best satisfy them. Liberal political values. A. Values of political justice. The values of equal political and civil liberty, equality of opportunity, values of social equality and economic reciprocity. B. The values of public reason, free public inquiry, political virtues as reasonableness and readiness to honor the moral duty of civility. Number 3. Constitutional essentials and basic justice. Basic structure and its public policies are to be justifiable to all citizens as the principles of political legitimacy requires. In making justifications, we are to appeal only to presently accepted general beliefs and forms of reasoning found in common sense. What other guidelines and criteria have we for this case? In discussing constitutional essentials and matters of basic justice, we are not to appeal to comprehensive religious and philosophical doctrine. Political conception is complete if it meets this condition. Number 4. The guidelines of inquiry of public reason as well as its principles of legitimacy. This means in justice as fairness that the parties in the original position in adopting principles of justice for the basic structure must also adopt guidelines and criteria of public reason for applying those norms. The argument for those guidelines and for the principle of legitimacy is much the same as and as strong as the argument for the principles of justice themselves. To fail to insist on this, they would not act responsibly as trustees. In justice as fairness, then, the guidelines of public reason and the principles of justice have essentially the same grounds. There is no reason why any citizen or association of citizens should have the right to use state power to decide constitutional essentials as that person's or that association's comprehensive doctrine directs. When equally represented, no citizen could grant to another person or association that political authority. Number 5. Keep in mind that political liberalism is a kind of view. It has many forms depending on the substantive principles used and how the guidelines of inquiry are set out. These forms have in common substantive principles of justice that are liberal and an idea of public reason.
We agree that citizens share in political power as free and equal, and that as reasonable and rational they have a duty of civility to appeal to public reason. Yet we differ as to which principles are the most reasonable basis of public justification. The view I have called justice as fairness is but one example of a liberal political conception. Its specific content is not definitive of such a view. The idea is that we must have such a criterion, and this alone already imposes very considerable discipline on public discussion. It is inevitable and often desirable that citizens have different views as to the most appropriate political conception, for the public political culture is bound to contain different fundamental ideas that can be developed in different ways. An orderly contest between them over time is a reliable way to find which one, if any, is most reasonable. Idea of constitutional essentials. We said about 4 $4.3 that to find a complete political conception, we need to identify a class of fundamental questions for which the conception's political values yield reasonable answers. There is the greatest urgency for citizens to reach practical agreement in judgment about the constitutional essentials. There are of two kinds: fundamental principles that specify the general structure of government and the political process, the powers of the legislature, executive, and the judiciary, the scope of majority rule. B. The constitutional essentials under A, which specify the general structure of government and the political process, and the essentials under B, which specify the equal basic rights and liberties of citizens. Essentials of the first kind can be specified in various ways. Witness the difference between presidential and cabinet government, but once settled, it is vital that the structure of government be changed only as experience shows it to be required by political justice or the general good, and not as prompted by the political advantage of one party or group that may at the moment have the upper hand. By contrast, the essentials of the second kind concern basic rights and liberties and can be specified in but one way: modulo, relatively small variations, liberty of conscience and freedom of association, and the political rights of freedom of speech. Voting and running for office are characterized in more or less the same manner in all three regimes. 3. Observe further an important distinction between the principles of justice specifying the equal basic rights and liberties and the principles regulating basic matters of distributive justice, such as freedom of movement and equality of opportunity, social and economic inequalities, and the social basis of self-respect. A principle specifying the basic rights and liberties covers the second kind of constitutional essentials, but while some principle of opportunity is surely such an essential, for example, a principle requiring at least freedom of movement and free choice of occupation, fair equality of opportunity, or as I have specified it, goes beyond that chat and is not such an essential. 4. The distinction between the principles covering the basic freedoms and those covering social and economic inequalities is not that this first expresses political values while the second does not. Both express political values. Rather, the basic structure of society has two coordinate rules. The principles covering the basic freedoms specifying the first rule, the principles covering the social and economic inequalities specifying the second. First rule, that structure specifies and secures citizens equal basic rights and liberties and institutes. Second, it sets up the background institutions of social and economic justice appropriate to citizens as free and equal. Whether the constitutional essentials covering the basic freedoms are satisfied is more or less visible on the face of constitutional arrangements and how this can be seen to work in practice. These matters are nearly always open to wide differences of reasonable opinion. They rest on complicated inferences and that require us to assess complex social and economic information about topics poorly understood. Thus, although questions of both kinds are to be discussed in terms of political values, we can expect more agreement about whether the principles for the basic rights and liberties are realized. To conclude that there are four grounds for distinguishing the constitutional essentials specified by the basic freedoms from the principles governing social and economic inequalities. A. The two kinds of principles specify different rules for the basic structure. B. It is more urgent to settle the essentials dealing with the basic freedoms. C. It is far easier to tell whether those essentials are realized. D. It much easier to gain agreement about that what the basic rights and liberties should be, not in every detail of course, but about the main outlines. These considerations explain why freedom of movement and free choice of occupation and a social minimum covering citizens' basic needs count as constitutional essentials, while the principle of fair opportunity and the difference principle do not. The Supreme Court as exemplar of public reason. At the beginning, $1.2, I remarked that in a constitutional regime with judicial review, public reason is the reason of its Supreme Court. I now sketch 2 points about this. First, the public reason is well suited to be the court's reason in exercising its role as the highest judicial interpreter but not the final interpreter of the higher law. And second, that the Supreme Court is the branch of government that serves as the exemplar of public reason. To clarify these points, I mentioned briefly 5 principles of constitutionalism. The first principle is lacks distinction in the two treatises between the people's constituent power to establish a new regime and the ordinary power of officers of government and the electorate exercised in day-to-day politics. The constituent power of the people sets up a framework to regulate ordinary power, and it comes into play only when the existing regime has been dissolved. Distinction is better higher and ordinary law. Higher law is the expression of the people's constituent power and has the higher authority of the will of we the people, whereas ordinary legislation has the authority and is the expression of the ordinary power of Congress and of the electorate. Higher law binds and guides this ordinary power. Third principle, a democratic constitution is a principle expression in higher law of the political ideal of a people to govern itself in a certain way. The aim of public reason is to articulate this ideal. Some of the ends of political society may be stated in a preamble to establish justice and to promote the general welfare, and certain constraints are found in a Bill of Rights or implied in a framework of government, due process of law, and equal protection of the laws. Together, they fall under political values and its public reason. This principled expression of higher law is to be widely supported, and for these and other reasons, it is best not to burden it with many details and qualifications. It should also be possible to make visible in basic institutions its essential principles. Fourth principle is that by a democratically ratified constitution with a Bill of Rights, the citizen body fixes once and for all certain constitutional essentials. For example, the equal basic political rights and liberties and freedom of speech and association, as well as those rights and liberties guaranteeing the security and independence of citizens, such as freedom of movement and choice of occupation and the protections of the rule of law. This ensures that ordinary laws are enacted in a certain way by citizens as free and independent. It is through these fixed procedures that the people can express, even if they do not, the reasoned democratic will, and indeed without those procedures they can have no such will. Fifth and last, in constitutional government, the ultimate power cannot be left to the legislator or even to a Supreme Court, which is only the highest judicial interpreter of the Constitution. Ultimate power is held by the three branches in a duly specified relation with one another, with each responsible to the people. The idea of right and just constitutions and basic laws is always ascertained by the most reasonable political conception of justice and not by the result of an actual political process. Number 2. Constitutional democracy is dualistic. It distinguishes constituent power from ordinary power, as well as the higher law of the people from the ordinary law of legislative bodies. A Supreme Court fits into this idea of dualist constitutional democracy as one of the institutional devices to protect the higher law by applying public reason. The court is to prevent that law from being eroded by the legislation of transient majorities, or more likely, by organized and well-situated narrow interests skilled at getting their way. It is indeed anti-majoritarian with respect to ordinary law, for a court with judicial review can hold such law unconstitutional. The higher authority of the people supports to it. The most innovative periods of our constitutional history are the founding, Reconstruction, and the New Deal. These three seem to rely on the political values of public reason. The Reconstruction amendments that sought to remove the curse of slavery and the modern activist so-called welfare state of the New Deal all seem to fit that description. The point is that the political values of public reason provide the court's basis for interpretation. A political conception of justice covers the fundamental questions addressed by higher law and set out the political values in terms of which they can be decided. The parliamentary supremacy with no Bill of Rights at all is superior to our dualist regime. It offers firmer support for the values that higher law in the dualist scheme tries to secure. Some may think it better that a constitution entrench a list of basic rights, as the German constitution does. It placed their rights beyond amendment by the people on German Supreme Court, and enforcing those rights can be said to be undemocratic. Political liberalism does not assert to deny any of these claims, and so we need not discuss them. The content of a political conception of justice includes the values of public reason by appeal to which the merits of the three kinds of regime are to be judged. 3. The court's rule is not merely defensive but to give due and continuing effect to public reason by serving as its institutional exemplar, the public reason sole reason the court exercises. It is the only branch of government that is visibly on its face the creative of that reason. Citizens and legislations may properly vote their more comprehensive views when constitutional essentials and basic justice are not at stake. The rule of justice says to do properly and have no other reason and no other values than the political. The best interpretation is the one that best fits that relevant body of those constitutional materials and justifies the public conception of justice or a reasonable variant thereof. Example, Bill of Rights guaranteeing the free exercise of religion or the equal protection of the law. The justices cannot invoke their own personal morality nor the ideals and virtues of morality generally. They must appeal to the political values they think belong to the most reasonable understanding of the public conception and its political values of justice and public reason. The idea of public reason does not mean that judges agree with one another, any more than citizens do, in the details of their understanding of the Constitution. The court's role as the highest judicial interpreter of the Constitution supposes that the political conceptions of judges hold under views of constitutional essentials locale the central range of the basic freedoms in more or less the same place. The court's role as exemplar of public reason has a third aspect, to give public reason vividness and vitality in the public forum. The court fulfills this role when it clearly and effectively interprets the Constitution in a reasonable way. The Constitution is not what the court say it is. Rather, it is what the people acting constitutionally through the other branches eventually allow the court to say it is, and more than marginal differences persist. The idea of public reason urges us not to do this in case of constitutional essentials and matters of basic justice. Public reason does not ask us to accept the very same principles of justice, but rather to conduct our fundamental discussions in terms of what we regard as a political conception. 2. A second difficulty concerns what is meant by voting or a sincere opinion. In principle of legitimacy, there are three conditions are satisfied. A. We give very great and normally overriding weight to the ideal it prescribes. B. We believe public reason is suitably complete. C. We believe that the particular view we propose and the law of policy based thereon expresses a reasonable combination and balance of these values. Public reason asks it that citizens be able to explain their vote to another in terms of a reasonable balance of public political values. The only comprehensive doctrines that run afoul of public reason are those that cannot support a reasonable balance of political values. 3. To specify a question is successfully resolved by public reason, we want our political conception of justice to be complete. Its political values should admit of a balance, giving reasonable answers for all or nearly all fundamental questions. To discuss several problems of extension, as this may seem unanswerable from within a political conception. 4 problems. 1 is extending justice to cover our duties to future generations, extending it to the concepts and principles that apply to international law and political relations between people, the traditional jus judicio. This raises the question whether an amendment to repeal the First Amendment and to make a particular religion, the state religion amendment with all the consequences of, or to repeal the 14th Amendment with its equal protection of the laws. It must be accepted by the court as a valid amendment. If the people act constitutionally, such amendments are valid. It is sufficient for the validity and amendment that it be enacted by the procedure of Article 5. The following reasons. An amendment is not merely a change. One idea of an amendment is to adjust basic constitutional values to changing political and social circumstances. The 3 amendments related to the Civil War all do this, as does the 19th Amendment granting women the vote and Equal Rights Amendment attempted the same. At the founding, there was the blatant contradiction between the idea of equality in the Declaration of Independence and the Constitution and chattel slavery of a subjugated race, to adopt basic institutions in order to remove weaknesses that came to lighting subsequent constitutional practice. The court could say that an amendment to repeal the First Amendment and replace it with its opposite fundamentality contradicts the constitutional tradition of the oldest democratic regime in the world. In the midst of any great constitutional change, legitimate, the court is bound to be a center of controversy. Emphasize that they are not intended as a defense of such review, and it aimed to elaborate the idea of public reason. Apparent difficulties with public reason. For political conception whose combined values of justice and of public reason yield reasonable answers for all. Everyone appeals to a political values, but agreement is lacking. Extension is the setting out the principles of normal health care. We may ask whether justice can be extended to our relations to animals and the order of nature. The tradition of the social contract and justice as fairness, by taking for granted the full status of adult persons in the society, forward to other generations, outward to other societies, and inward to those requiring normal health care. Claims of animals and the rest of nature. Animals and nature are seen as subject to our use and wont. Numerous political values. The good of ourselves and future generations by preserving the natural order and its life-sustaining properties. To foster species of animals and plants for the sake of biological and medical knowledge with its potential applications to human health. To protect the beauties of nature for purposes of public recreation and for the deeper understanding of the world. Political liberalism itself cannot argue each of those comprehensive doctrines. Political conception has a reasonable expression of the political values of public reason. Important difference. The status of the natural world and our proper relation. citizens can vote their non-political values, a reasonable and effective political conception. The limits of public reason, fundamental political matters, given explicitly in terms of comprehensive doctrines, given but not the supporting doctrine itself, present what they regard as the basis of political values, understand the ideal of public reason, the exclusive and inclusive. Exclusive view has different political and social conditions. Inclusive view allows variation and flexible ideal of public reason. Appropriate limits of public reason vary depending on historical and social conditions. And ideal of public reason in appropriate complement of a constitutional democracy. Ideal cases. Members recognize a firm overlapping consensus of reasonable doctrines, no great interest in introducing other considerations. Fundamental rights are already guaranteed, no basic injustices they feel bound to protest. A serious dispute in a nearly well-ordered society and applying one of its principles of justice. Society is not well-ordered and there's a profound decision about constitutional essentials. The content of public reason, namely, substantive principles of justice for the basic structure, guidelines of inquiry and conceptions of virtue that makes public reason possible. We honor an ideal of democratic citizens trying to conduct their political affairs, expresses a willingness to listen to what others have to say and ready to accept reasonable accommodations or alterations in one's own view. Account of public reason are possibly 2. The central place of the duty of civility as an ideal of democracy. The content of public reason be given by the political values and guidelines of a public conception of justice. That's all. Thank you.